All right, buddy. Hey, everybody, this is Craig Kirk at the Craig Kirk School of Common Law. Check me out at craigkirk.info. craigkirk.info, Craig Kirk School of Common Law. And we're going to be talking today about the Southern Antebellum black codes implemented through the 14th Amendment on all states. Now we have it implemented in every state, and we call it the state's compelling interest for automobiles. We're going to talk about debtor prisons. We're going to talk about what happened down there, and let me pull the document open real quick here. I got it right here. We're going to talk about the, give me just a second, the Antebellum. We're going to talk about the Greta case down there in Hurricane Katrina crisis, when the City of Greta, Louisiana, police barricaded the federal highways, denying would-be evacuees the ability to flee from the flooding city of New Orleans, and ensuring action for infringement of the, and then it goes on to say here, would-be evacuees' constitutional right to intra-state travel. Federal District Judge Mary Ann Vial-Leming dismissed the matter in Dickerson versus City of Greta, holding that while there is no doubt that the fundamental right of interstate, not intrastate, interstate travel exists, Supreme Court has not ruled on whether a right of intrastate travel exists. This court declines to find that there is a fundamental right of intra-state travel. The Fifth Circuit affirmed the ruling. Okay, now the question is, what insurance are they using to predicate this thing to happen? Look it up, ladies and gentlemen, students, people, fellow YouTubers. One way or another, it is the Stafford Act. It's federal legislation. On there, they come in there and take your firearms. They take your food. They take whatever they want. They arrest you, put you in FEMA region 6543211, 10, how many FEMA regions there are, according to Alex Jones, whatever. So they take and take all your stuff under the Stafford Act, federal legislation. The attorneys never argued the Stafford Act. This is common when you have credulous attorneys not making the case about federal legislation impeding my rights to survival. I have a compelling interest of the state. Why? Because the state is not there in operation. So the state is not there in operation, and nobody's there, and I have a right, and there's nothing there that I'm impeding, and the state can't raise nothing because it's not there, or this understated state. I'm sorry. Let me retract that. The City of Greta, or the city, is not there because there's nobody there being impeded on. So they're not there. So I'm there by myself, and I have a right to leave, so they close the gates. The Stafford Act provides for this. Let's think about that, the Stafford Act. So I'm getting a little excited here, twist my words a little bit, but nevertheless, the Stafford Act was the vehicle that which allowed the city to do that. And not only did they do that, they used private contractors, from what I'm told. They used military, and they used state and local law enforcement. Furthermore, there was potential people and law enforcement running around as kill teams. So we have a lot of mysterious deaths, a lot of fires that should not have happened. So we're going to shift gears here just a little bit. Okay, so here is another doc that I got. This is the ACLU out of Ohio, and I'm not an ACLU fan. I don't like some of their political stuff that they're doing with destroying the fabric or pushing the agenda of all people have rights and marriage and the civil union and gay marriage. I'm not for that, but hey, you want to do that, that's fine. That you have to pay the penalty, not me. I don't care. Whatever. Hey, whatever. This here is a ACLU document. To the Honorable Paul Lux, Judge of Erie County Municipal Court, 150 West Madison Road, Millen, Ohio. And this ACLU sent him a document. We got the rise of debtor prisons. and we got the rise of debtor prisons. And here's what my research has shown. They're monetizing the cases. Suggests this. It doesn't really show it. It's a theory. It's suggesting they monetize the court cases. It's a lot of rumor and hoopla and patriot mythology and all. Maybe it's true. Maybe it's not. But at the same time, it's my belief and understanding, looking at the debtor prisons from 1833, that the state can, within the territorial jurisdiction of the county and the cities, under the home rule. Remember, under the home rule, we're constitutional cities. Under the home rule, we can do whatever the hell we want to do. Is that so? Well, let's go test the home rule. Okay, so the counties and the cities, it's presumed that within their territorial jurisdiction or the county territorial jurisdiction can buy what? Debt. Can buy your mortgage. Can buy your credit cards. Can buy the liens. It's presumed because we're looking at an international framework. We're not looking at the microscope at the lower level. Won't do that. Ain't going to go there. Looking at an international level. So, we're looking at national receivership. We're looking at national sovereign debt defaults. What does it look like? Who runs around and takes the nations into captivity under scriptural law? What is the problem? What are the children of America doing? Pledging their property. How are they doing it? Credit card loans, usury and interest, unjust weights and measures. There's a natural law penalty for that. It's built in the environment. God built that in the environment. A lot of people don't object to it. Interest, usury and interest. Well, there's a penalty for that. America's going to pay for that. But nevertheless, let me go on to explain. There's a lot of things you can do for yourself. This is educational. Take it with a grain of salt. Study it. Think about it. And look at your county from the of purchasing mortgages and credit cards. I'll take a quick side note. City of Cleveland, Bank of America, or other banks demoed the property, transient real estate's a transit, demoed it, and then gave the land back to the City of Cleveland. So the letter goes on to say, from the ACLU, says the Sandusky Register recently ran an article written to Tom Jackson titled "Pay, Fine, or Do Time." That was brought to our attention. This article detailed the practices of various area judges with regard to dealing with individuals who have, for whatever reason, not paid fines or court costs. At this time, we have not independently verified the accuracy of the facts contained in the article. However, if the article is accurate, there is cause for concern. That's the ACLU. The article did mention you and your docket specifically. One case mentioned was that of the Tara guy who appeared in your courtroom earlier this year and was sentenced to 10 days in jail, 10-day jail sentence. If she, no, that was it was a woman. Tara Guy, that's a woman. I'm sorry. If she failed to pay her fines and costs, the article responded that the courts have taken the position of the defendants who are sentenced to jail for failure to pay must pay the fines in full, even after they have served their time in jail, and that you do not permit jail time to substitute for fines. If this is true, the Erie County Municipal Court's sentencing practices appear to be in violation of both Ohio statutory and existing Ohio case law. Notice it didn't say common law or constitutional law. I'm not so sure that that's even a violation of the state constitutional law from the aspects of the 1830s. So that's the first disc here. We're going to take a break here, and we're going to go on to the next, the second one to this. So I'll be right back.